Welcome to Undoing I Do with Stephanie and a Day. I am Stephanie Hunnell, the owner of the Hunnell Law Group in Asbury Park, New Jersey, and your co-host for this evening.
And I am Adela Sherilyn Dow. The law offices of Adela Sherilyn Dow is my business. And I am also your co-host for this evening, shooting live out of Staten Island, New York. How are
Nice.
you?
Good. How are you?
I'm great. So, the other day we had a comment saying that we needed to get to the point on something sooner than later. And I was like, we are like a talkable, but you're a talkable bunch of people. Talkable is not a word, but we like to engage with our audience and see how everybody's doing before we get down to the brass tacks of things.
Agreed. And also, as we talk a little bit, we kind of give people time to log in.
That's
So we're not
true.
like jumping right into a topic that's going to be amazing and important. We have a little bit of conversation. Plus, you can't really stop us from talking.
Exactly. Plus I just like to chat. So,
That's what I was saying, my big old mouth.
So we are talking tonight. We're gonna get into it today. It's a minute and 20 seconds, so we're gonna really get into it today, real fast.
We are. We have a lot to cover, I think.
We are going to talk about disability benefits and how they affect your child support obligation. The New York side of this stuff is going to be the sad, boring story. I'm just here to tell you guys. It's going to be the sad, boring story. Like, why did we even? Yeah.
Anyone that has a child support obligation and is disabled is going to want to come to New Jersey and move here with their kids. So
Absolutely. Absolutely. They're about to come over to Outer Bridge right now.
Yeah. So let me start off by saying then, in that case, in New Jersey, there is a child support guideline. We've talked about this many times before on the show. And essentially what happens is we look at the mom's income, dad's income, various expenses like health insurance, daycare, those kind of things. And the guideline spits out a number and says how much child support should be paid. When somebody is disabled, the disability can impact their income. So that's the first prong of this. There's also a piece of this that if the child receives a benefit, there's some other additional impacts. But before we get into all of that, is there anything similar in New York for a parent that is disabled and seeking a child support reduction?
So it's going to depend. It's going to depend upon, first of all, when you signed your agreement, and it's going to depend upon whether your child support is based upon an agreement or whether it's based upon an order. All right. So if you signed an agreement and your agreement was signed prior to October of 2010, when the new rules for modification in New York came about, you're going to be held to a higher standard, which is an unforeseen change of circumstances. There's case law and there are judges who say that it can be foreseeable that someone would become disabled. You know how I feel about that?
Yeah.
I think that's some kind of hogwash right there, but
So let me
what
ask
it is.
this. You're saying an agreement versus an order, right?
Right. So now if you have an order, right, because an agreement you negotiated for. So that's why the standard is an unforeseen change of circumstances. You negotiate for that agreement. But if you have an order, then the basis is a change of circumstances, which a disability could just be a change of circumstances. It doesn't need to be unforeseeable in that situation. All right. And then if you signed an agreement or got an order after October 2010, then we're in a change of circumstances situation or a reduction of income plus or minus 15%. Okay, so if you have that reduction, you'll be able to look for the modification and probably be successful at the modification. I remember trying cases prior to that change in the law for orders that were incorporating agreements that people did. and being so annoyed that these people had these major issues happen in their lives. And judges would say, well, that was foreseeable. You made this agreement and you didn't negotiate for a downward modification in the event that you had a disability.
Right.
Who thinks about these things?
Right.
When you're negotiating, you just want to get it done and get it over with.
Mm-hmm. And how can you possibly list every foreseeable thing that could happen?
You can't, because we don't have a crystal ball.
Right. I mean, I guess there could be a catch-all of a few things after you would know about. I mean, that's just crazy.
Mm-hmm, mm-hmm. Well, and so I quickly said to myself, and these were judgments that I hadn't been on, right? I hadn't drafted any of these agreements or judgments. So I quickly incorporated language into my documents, which would allow for people to file in the event that they had a change of circumstances due to disability, etc.
Right. Yeah, of course. Whenever those things happen, you have to, I mean, that's why these property settlement agreements can end up being, 30, 40 pages long, depending on the circumstances. Because sometimes you have these huge paragraphs, and we put all of that language in there to protect you, because there are these cases that we know about that require certain language and foreseeable or not foreseeable. And what do you consider that? I mean, I know with alimony, especially when you're talking about non-modifiable. I mean, it's half a page long of all of the things that would qualify and say it's still not modifiable. So I'm sure it's very similar with that language for child support and disabilities and stuff.
So the good thing about it is that nowadays you don't have to put all of that stuff in, right? I mean, you're talking about the anti-lepus language and this and the other. Nowadays we don't have to put all of that stuff in New York. You can rely upon the change to DRL 240, which says that if you have that first of all, you're entitled to a review every 3 years. Okay. Second of all, if there's a 15% plus or minus difference, you're entitled to a de novo review. De novo means brand new. And then again, if you have a change of circumstances that you can prove, and a change of circumstances that you can prove, which is not something that you brought about yourself. So it cannot be that you're like, bump this child support, I'm not about to pay it, come get blood from a stone.
So
that won't work.
I want to go back. I want to get back to that point. I'm just making a little note because I want to get back to that, because I want to really just quickly, because New Jersey is very similar with regard to the change of circumstances. A disability would constitute a change of circumstances for you to have a review of your child support. The prior case law or prior statutes were there was a presumption that if you qualified for Social Security disability, then you meet your burden, and then the other side has to prove that you do have the ability to work, or you are actually working and you have an ability to earn and get income. There was a case that happened a few years ago that says we really are going to look at it. Yes, you can qualify for a change of circumstances, but that doesn't necessarily mean you qualify for a reduction of support. So there's still the back and forth that goes on with determining income. I also want to point out that you don't have to qualify for Social Security disability to prove you're disabled. If you have doctors and medical records and all of that to prove there is a disability, then you can still qualify for a change of circumstances, obviously provided you're no longer working. And the reason you're not working is because of a disability.
Right.
But what you said made me triggered a thought in my mind, when you can't actually cause the change of circumstance, which is the same in New Jersey. So sometimes this has happened. The question it comes up when somebody is abusing substances and they've now become disabled, or they qualify for a disability because they have medical issues related to some sort of substance abuse issues and are no longer capable of working. And I've been on both sides of those, arguing that, yes, it is a disability. And then also arguing, this was really a self-created problem. And unfortunately, in some of those cases, we're talking about means-based disability that the people are receiving, because they might not be receiving the normal Social Security disability benefits. They're just receiving it based on them not having any income.
Right. So like SSI.
Like SSI. Yes, SSI. which, so what happens in New York? Is there any clear case? I don't think there's any clear, I mean, I've argued both sides, so there's some gray area.
There isn't, but I will tell you that if you are arguing this, right, and you're arguing it with respect to being the spouse who's getting the money in, right? So in other words, you're the payee.
Mm-hmm.
And you say, well, look, she's been abusing these drugs for, 5, 6, 7, 8 years. And then you want to impute income to the person, right? You're probably, if you're in a divorce, you're probably going to be in a situation where the court says, okay, but you were there for all of these years and
Mm-hmm.
you tacitly allowed this to happen. And so if that's what his or her or their status quo has been, what do you want us to do to make that different?
Right.
So that's another part of the puzzle that you can sometimes get into a problem with if you're the spouse who's trying to impute income to the other person.
And it really just shows how fact sensitive all of this is. Because if the drug issue or alcohol issue or whatever came up after the judgment of divorce or after the final judgment in a non-dissolution case, then you have a different argument to make because it was something that happened afterwards. It wasn't, there is a change of circumstances since that order was entered. You're not looking to impute a higher amount of income because they had, a capability of working. Yeah, I just lost my other point that I was going to make. Oh,
and so
our prior show.
What were you saying?
No, I was just going to say we brought something up similar in our prior show with custody and parenting time to say you can't call somebody a bad parent when they've been using drugs for the last 5 years and you've been together and you knew they were doing it. It's a very similar argument with the child support.
Yeah, so that we were talking about that on our buddy John Knocklinger's show on Divorce Shield.
Yes, that's what it was.
Which we did last week right after our show. And yeah, that was a thing, we were saying, okay, you're going to have this argument, but this has been going on for all these years. And so now it's a problem. Yeah, we should do a whole show on that. John had a great idea with that. We should do a whole show on that. I don't even know how we got onto that last week. And thanks, John, for having us on.
Yes, but shout out, John.
But, it's difficult because you have a situation where some people say to themselves, look, I'm on disability. I should be able to get some kind of reduction by virtue of the fact that I'm on disability. But you just said something, which is the same thing in New York. The fact that you are on disability or SSD, the fact that you are even on a disability pension does not necessarily mean that you're going to be rubber stamped for a reduction. And one of the reasons why is that a lot of people make more money when they're disabled than they did when they were on the job. And so there's this belief, this misapprehension that if you're on disability, automatically that's the only money that's going to be considered for the purpose of figuring out how much you can pay for child support, and that the workman's comp money won't be considered. And any kind of other benefit, disability insurance that you're getting won't be considered, and that's not the case. And so in those circumstances, when I've had clients who have 3 new sources of income now, right? They have the disability pension, which is a different level of pension than a service pension. Usually you're earning more money because you're getting paid not only for your service, but also for the fact that you got injured, if you got injured on the job. And then you're also getting, if you are injured on the job, workers' compensation, right? And then on top of that, you're getting SSD.
Yep.
All of those other streams of income are going to be considered for the purpose of figuring out what your child support obligation is. So you might want to be careful, because if those incomes come up to more than what you were obligated to pay in the first place, I'm pretty sure you're not trying to file to get an increase.
And also, it's like an elephant in the room, I guess. people also work on the side. So once they are qualified for disability, they now just think, okay, this is the court's going to rubber stamp this. And they're out there doing side work. A lot of people that are doing construction or house cleaning or whatever little work that they're doing, thinking that they need a little extra money. And that shouldn't count because that's my extra money to, for extra expenses. But no, all of that counts. So if you're doing the side work, your ex is going to glom on to whatever you're doing and they're going to know all of your business.
They may be right outside with the binoculars.
Oh my God. People, you slap a sign on your truck so you can get a write-off, right, for your taxes. And you call, this is your, landscaping business. Well, your ex sees that and knows, oh, he has a landscaping business or she has a landscaping business. Here's a picture of this. So they say they're disabled, but take a look at this. And the
that reminds me of those hidden camera shows. Or somebody's like skiing, and they're supposed to be disabled. Yeah, don't get caught out there like that because there are some lawyers out there who will have you followed by private investigators so that they can assist their client in showing that you really aren't disabled. So do not get caught out there like that. Put the skis away if you are about to pull those skis out. Please do not.
We had, I don't know, maybe 15 years ago, we had a case. This woman was absolutely said she couldn't work. She came into the courtroom with a walker and she was just really badly injured. I forget, something with her knee or her ankles, I forget. And she always came with orthopedic shoes. So we had a private investigator follow her. And there's these scenes of her getting out of her car with her high heels. She walks over, she pops open the garage door. They didn't have the automatic door. Pops open the garage door.
Oh, she was lifting the garage door. Oh, okay. Okay.
Jumps back in the car, drives the car into the garage, walks. I mean, yeah. I'm like, okay. Mm-hmm.
Listen, that is so basic. You really need to cover your that is basic. That is an amateur mistake. Please do not. And if you do, recognize that that's not going to vote in your favor. Your petition is probably going to get dismissed. It's probably going to get dismissed. Yep. And if you file another one in front of the same judge, you're not going to get too favorable of a situation.
By the way, for her, I mean, it was for alimony purposes. For her, it just gave her no credibility.
Exactly. Yep. We have spoken about that so many times on this show.
I think in this day and age, people are more aware of being recorded maybe than back then.
I hope so. Because sometimes I'm not sure. Sometimes I'm not sure, with the cases that we do, and the videos and the audio that we get. Sometimes I'm not sure. Sometimes people just they get lost in the moment.
Yep. Some of the emails I see, I'm like, you knew you wrote this and why? Why did you write this? Why did you put this anger in a text message?
Right. So now if you are putting in your text message, I can't get Johnny this weekend because I have to go and help XYZ person put in their ceiling fans. Mm-hmm. And you know that you're about to file for a downward modification because you're disabled. You should not be texting this stuff or emailing this stuff to your adversary. Yep. I mean, look, there's nothing wrong with making additional PIN money to support yourself, but you have to recognize that if you're doing that, you're only going to be harming your credibility if you're not candid with it. Right. If you're candid with it, it may be another story, because if you say, look, I was only doing this because my child support obligation still is $1,000 a month and I can't live because I then only have $500 to live on. So I have to do something. Let it be known that this is why you're doing it. Don't hide it and act like the money doesn't exist, because once the court finds out about it, and they almost always will. Yep. Once the court finds out about it, you're going to be in a pickle. Mm-hmm. Now, go ahead.
No, I was just going to say, by the way, a lot of times what happens is your application doesn't get granted right away. Some people have to appeal. And so that could take a long time. And while that's happening, you might have to work and you might have to do something to make a little extra money. But again, exactly what you said, be candid about it. And then once your approved for Social Security disability, then you need to stop doing that extra work unless you are going to continue to do it, in which case it should be calculated for child support.
Exactly.
I mean, it's for
Exactly.
your child. That's the bottom line. And the courts want to make
Now,
sure that they're protected.
now here's what you just said, something that triggers me to say what I have to say about New York and the derivative benefit. The derivative benefit is the money that your child gets by virtue of one of the parents being disabled. Generally, that money goes to the custodial parent. Okay. And the custodial parent is seen as the child's representative payee. Okay. So here's the deal. If you're in New York, don't think that that money is going to help you because you're the disabled parent and your child is getting this money. It will not help you. The case law in the state of New York says that the money that you get, and there's a case that I wanted to talk about, Pinto versus Putnam County. If you all want to just look at it, Putnam County Support Collection Unit. This person gets money. Let's say that they get $1,000 extra a month for the child. The custodial parent is getting the child support plus the extra grand, right? So the non-custodial parent's probably like, hey, look, because of me, Johnny's getting an extra $1,000, which means that Cynthia is getting an extra $1,000 for Johnny. Why should I have to still pay $1,500 a month? Why can't I pay $500 a month? Why can't that be in lieu of the money that I would have to give for Johnny? In the state of New York, the extra $1,000 is Johnny's money. And Cynthia or John Sr., whoever is the custodial parent, can do whatever they want to do with that money. They can go on vacation with the money. They could get a new car with the money. I could just think of a whole bunch of stuff that I would do with the $1,000. So that's the way that works in New York.
Not for Johnny, but for Cynthia.
Or John Jr. Or no, John Sr. That's his name. John Sr.
Yep.
His name is John Sr. And so, no, you're not going to get any reduction, even though there's an extra $1,000 coming into the household, because New York state law says that it's not coming into the household. It's for Johnny.
Right. Which is exactly the opposite in New Jersey. So in New Jersey, it specifically says that non-means tested government benefits, which is like as long as it's not SSI, must be deducted from the basic child support obligation. And that's under the actual court rules and the case law. So there's like the case of Deal. And it says the reason behind that is because that money reduces the overall contribution of both of the parents for support, because it can be paid in lieu of. So now, for example, if your child support obligation is $1,000 and Johnny is getting $1,010, your child support would then go down to zero.
Right. That is not going to work for you in New York, people. Y'all are listening to this. It is not going to work. You're not going to get a negative child support obligation or zero child support obligation.
Yep.
And so, that money. So here's the thing. This is my suggestion. So if you're in the middle of a divorce and you're getting that money, you may want to try to see whether you can negotiate for that money to go to college funds, to pay education, something like that. Now, there's no case law that says that it has to be done, because obviously the case law says that it's the child's money. But you may want to try to appeal to the other person's sensibilities if your spouse or ex-spouse is the person that you can appeal to, in order to use that money for Johnny's benefit, but in a way that offsets an obligation that you may have in the future.
Right. Mm-hmm. Which makes,
because otherwise that's just a lost $1,000 right there.
Mm-hmm. We had this conversation months back because I had a case that was going on regarding government benefits and retroactivity. So in New Jersey, you're actually not only are you able to just get that benefit and get a reduction, you're also allowed to get a retroactive reduction to the date that you filed your first motion for a modification. So if, for example, you were entitled to Social Security disability and you were getting some derivative benefits, let's say you were approved in 2020, but you filed your application in 2018, but you were denied, but you still filed your motion. If you filed your motion in 2018 and then in 2020 your benefits were granted, you get retroactive disability benefits back to the date of your disability. The child gets extra benefits. So the court can go back and is supposed to go back, according to the case law, to 2018 when you filed your first motion. So in New Jersey, it behooves you, even if you're not sure and you don't think your application is going to be granted at this time because you haven't been approved for disability, you should still file your application, explain that you're disabled, attach the appropriate proof that you are disabled. So you need doctors, notes. You can't just file an application, say, I'm disabled, I'm not working anymore,
Right.
and expect the court to go back to that date. You have to have provided some proof. But then you can get the benefit of that. Now, if the child gets the derivative benefit, you'll also get the benefit of that up to the amount of your arrears. So if there's anything extra, you're not going to get a credit. So if you had $5,000 of arrears, but Johnny got $10,000 of extra benefits, that extra $5,000 goes to the parent of primary residence. It goes to Cynthia, and she can, choose to do whatever she wants with that money.
Right. Right. And that's as close to New York as you're going to get in the state of New Jersey. And so if there's extra money, great. If there's not, you're not getting anything from it. You can't profit off of the fact that the child's custodial parent got this money.
And it just blows my mind with New York when we were talking about this months ago, because I never knew that. So I always learn new things on this show and through talking to you about this stuff. But considering that child support is the right of the child, and we want to make sure there's no financial hardship, you would think that it wouldn't just I don't know, they would just say, here, take all of this money. Because if you have the child support obligation plus the Social Security, how can the other person actually afford that extra child support? If they really truly are disabled and can't make the money, the child is not benefiting by having a parent that's going to be in arrears constantly.
Right. And so, and the only way that you can really get out of paying guideline support is if your income is below the poverty line. So if you're below poverty level, the base amount of child support that you can pay in the state of New York is $25 a month. Mm-hmm. Okay. But if you are not at that point and you are not successful at arguing that the award of child support is unjust and unreasonable, then nobody's going to give a daggone. And see, this is where, this is where we have a problem, because if somebody really does have a genuine and bona fide disability and they can't work at all, mm-hmm. they are going to be in a situation whereby, they are looking at incarceration, loss of driver's license, loss of passport, loss of professional licenses. I mean, obviously you're not working, but you can lose your hunting license if you want to, if you hunt, mm-hmm. or if you fish, you have a fishing license, you lose all of that. And you're not able to afford. So,
No, go. I didn't mean to cut you off, but I was also thinking that I can also see where then when the child is with the other parent, it's kind of where I was getting at before, is that child then can't necessarily be supported by that parent while they're together, because you can't go to the movies. You might not, you can't go out to eat as much as you would want. You can't buy the, fancier clothes, or even sometimes just the basics.
The basics.
Right. So when is Johnny's never going to want to go and visit, John Sr. or Cynthia, whoever is the, parent of alternate residence, if there's no money to be had, and if he or she is living in a 1-bedroom apartment, because that's
or worse, yeah, living in a room. Mm-hmm. Imagine a 1-bedroom apartment might be luxury at that point, because they might be living in a room. Mm-hmm. Now this bleeds into all other types of stuff, right? Because now, if you're living in a room and the room is not, obviously the room is in a rooming house and it's not mm-hmm. suitable for the child to come over, now we're getting into the issue of lost parenting time. Oh, well, we won't let you take Johnny to this apartment because you share this apartment with 3 other people and we don't know who those people are, but you can take Johnny out. You can meet Johnny at the mall. You can meet Johnny here. Okay, so now I have to spend more money because as soon as Johnny gets to the mall, Johnny's going to want to go to the Lego store. Johnny's going to want to go, here, there, and everywhere, GameStop or wherever, and I don't have the ability to pay for that. So it really does. The policy really does bleed into so many other social aspects that the court has not adjudicated and addressed properly, as far as I'm concerned.
Right.
That's, look, and this is when I'm talking about when people really are at the ends of their financial ropes. Not people who are gaming the system and stuff like that. People who are gaming the system should not be able to profit and succeed off of, hardworking people who are propping up the quote unquote system.
Right. And I do think as far as in New Jersey with the new case law, and there's not that presumption anymore where there's just a change of circumstances and you have to prove that you're still not capable of working. I think that kind of addressed the issue of people gaming the system with this. Oh, here's my disability paperwork. I'm automatically at this level and nothing more, unless you can prove that I'm capable of working, but it's, not the same. And I think that helps with what was happening is some people were gaming the system. I mean, that's what happens, unfortunately. That's how a lot of laws come about, by the way, is because people do something that they're gaming the system. And so we have to have this sometimes overreaction to fix the problem.
Right. The overcorrection. Right.
Correct.
Yeah. We gave a lot of information during the show tonight. I hope that everyone got something out of it and that you are able to use it and apply it in your life in the event that you're ever in this situation.
Agreed. And I hope you join us next week on Undoing I Do.
Thanks for watching. Share and like and let your friends know that we were on.